I'm Dan Antonelli. I'm an estate attorney here in New York City, and today we're going to talk about the frequently asked question, if I die without a will in New York, what happens? If a person dies without a will in New York, it's called intestacy, simply meaning you don't have a will. And then, since there's no will to direct who's entitled to your money and who is to be in charge of your estate, the rules of intestacy take over. And some of those rules include that the person who is entitled to be in charge of your estate would be called the administrator, and that person is typically the spouse. It could be the children, and if you don't have a spouse or children, there's a list in the statute that explains exactly who has the right to be in charge of your estate. Then the other part is who inherits. If you die in New York without a will, there is a statute that explains exactly who inherits, and it follows a similar pattern as to who is entitled to be the administrator, but it's not exactly the same. Typically, intestacy covers all your assets except some that are, let's call them special. Something like a joint account where there's your name and someone else's name on that account. In that case, that account wouldn't pass through your estate through intestacy. It would go to the surviving joint account holder. The same thing holds for many other assets where there's a joint holder or a designated beneficiary. So the bottom line is that if you want to control who gets your assets after you pass, you need to do a will.